I am Dr. Patrice Berry. I'm a licensed clinical psychologist, and here I share educational information on a variety of topics. So, a lot of things came up recently with the Jessy Kurczewski, I can't say the last part, Jessy case. And sometimes she's referred to as like the eye drop murder. Like, that is what she's referred to sometimes on social media. She was found guilty, and at her sentencing, a lot of surprising stuff came up. So for anyone that hasn't covered or hasn't heard about this case, I want to start with just a brief overview. And this article just did a good job summarizing everything. So this is about a 2018 death of beautician Lynn Hernan, with authorities claiming that Jessy staged an overdose scene and stole more than $290,000 over time from Hernan while I guess Jessy was taking care of her. Sounds like she was some type of caregiver for her. And I don't think it was like a paid caregiver. Like, I think she was supposed to be a friend, but yes. Hernan, who was found deceased in her condo on October 3rd, 2018, she passed at the age of 62 from a chemical found in Visine drops. But Jessy and her defense team claim that Hernan was having thoughts of unaliving after years of poor health and financial troubles, and had consumed the eye drops mixed with vodka over some time on her own. Okay, well, let's get to the fact that Jessy was found guilty. This was posted on November 13th, 2013. I do believe that was the day of court. I could be wrong. But back in November, a jury returned a guilty verdict on all counts in Jessy's case. And Jessy was very distraught in court after that. And the jury was asked, was the property stolen more than $100,000? The jury said no. But the jury returned that it was worth more than $10,000. So I guess the jury didn't think that the prosecution proved that she had stole the over 200,000. Okay. So we talk about jury deliberations and all of that. All right. So Jessy found guilty. Now let's fast forward to the day that was supposed to be her sentencing. And I'm going to play a little bit of what the judge said, but I just want to share some of the writings because I think you have to see some of this to truly understand what's going on. I will make sure to link the articles that I've shared down below. So Jessy's sentencing has been delayed after the prosecution submitted a written letter that they allege Jessy wrote. And there are some allegations in the letter about things that the lawyers might have done. And the lawyers confirmed in the hearing that some of the things are written on the back of some of their trial notes, that they know their handwriting and that some of this was written on the back of their trial notes. So let's just get into it. The sentencing for the eye drop trial has been delayed after the discovery of a 37-page letter the defendant allegedly wrote. And she alleges that she did not write it, but let's get into what it actually said. And both of her lawyers requested to be removed from the case. And after the judge asks Jessy what she wants, and Jessy so we'll play that part. But basically, the lawyers were released from her case. So now she has to get a brand new set of lawyers for her sentencing, and then also if she does any appeals. So this letter right here is from Kuchler and Cotton. And I believe these are the defense attorneys. And this is to Judge Durail. Forgive me if I'm saying that wrong. Our office filed a motion to withdraw last week and requested a hearing. From CCAP notes, it appears that the court plans to address our motion at the start of Jessy's sentencing hearing on Thursday. I asked the court to sign the withdrawal order in advance of that hearing, and that did not happen. So they did have to show up to court. And all of this happened in open court, which the judge was upset about. Like the judge wished that they had submitted something so that they didn't have to have this public hearing where it was streamed, talking about this alleged letter, and they talked about it all. So I guess the lawyers could have had a closed door conversation, or they could have filed something under seal, and that did not happen. So they submitted a motion to withdraw as counsel. Given the state sentencing materials identified as court document number 567 with the defendant's knowledge, this matter was discussed with the Wisconsin State Bar of Ethics, who opined that withdrawing as counsel was in the best interest of all parties. So this is attorney Pablo. He is saying that he consulted with the state bar, and the state bar advised that he should likely withdraw based on the letter that allegedly was written by Jessy. That's huge. But let's get to the actual letter, because we have pieces of that here. This was all filed and it's available. Okay, so the prosecution, I believe, is the one that actually filed it. So yes, this is the Office of the District Attorney, Susan Opper. Dear Judge Duro, enclosed is a packet of 37 pages that are dated November 22nd and were received by the Waukesha County Sheriff's Department on November 26, 2023. This packet of papers is comprised of Miss Jessy's initial letter to the recipient, followed by many pages of instructions whereby Jessy asks and instructs the recipient how to create fraudulent documents along with a fraudulent cassette tape recording. I've already glanced at the note. Okay, let's just keep going. The recipient received this packet of papers at her home and was disturbed by what Miss Jessy was asking of her. And ultimately, the recipient decided to turn them over to law enforcement. The state wishes to point out that the original paperwork was double-sided, which is important to note as Your Honor reads through the papers, because Jessy's instructions were written on the back of her own trial notes pages from the recent trial held between October 23rd and November 14th. For example, pages 17 and 18 of this packet are the same, but for the exception of a post-it note Miss Jessy utilized as means of showing the recipient where the recipient should place the fraudulent copy of a notary stamp on that document. Page 19 then is the reverse side of the same sheet of paper and contains Jessy's notes taken during trial. The same is true of pages 20 and 21. So they go into all of that. Let's get into the actual pages. Dear Jessica, I wanted to thank you for being a friend through this crap. I mean that. Some days I feel so alone, and now even more so. I feel very selfish lately, and I hope maybe I told you. Yeah, I hope there's a little I up there. I hope I told you I'm sorry for your loss. Your brother, I haven't asked either how you're doing or your kids. I hope all is well. And so this initial page is just kind of her talking about all that she's going through, not wanting to face life in prison. So please go, if you want to read over all of this, please do so. But let's get to the instructions. This is directions. This is what I need. Do you remember hearing about the park, Whithall Park, where I buried things? That was 100% true. The difference is 6 months later or so, I regularly went on walk there daily. That area was prone to flooding and the bag was sticking out one day. So I dug it out and ended up throwing away. Only person knows that, my attorney. That's what this says. Everyone else believes it's in the park or never was. It was part of the, I don't know, the Visine bottles Lynn had dated from her mom's death. I never told anyone that. Notarized papers of hers in a cassette. She specifically put spelling question mark tape. Old school voice recording of Lynn. All confession stuff that I kept hidden and quiet, I believe, because that says quite, but I think it means quiet. I don't know if I ever told you about Lynn's mom, blah, blah, blah. So it just goes on, but like it lays out in these 37 pages, there are directions of how to make something look old by writing it multiple times. Like there are all these directions of like how to forge a document, things you'd need: computer, paper, envelopes, stamps, address labels, cassette, old school, cheap ones. Able to record voice, gloves, must, if you help. Make sure you wear gloves because you are not getting in trouble. You're helping me. She's asking someone to, so if this is true, because these are allegations, like this is a letter asking someone to create false documents and like false evidence. But she's saying, I have the original did exist, but I threw it away. And I need you to do this so that this will help me down the road. So once again, I like to talk about things from a psychological perspective. And to me, this comes off incredibly manipulative, very manipulative, that she is trying to get this friend to do these things and is kind of twisting things of like, oh, like just wear gloves. Like if you help, you're not going to get in trouble because you're helping me. No, like if her friend was to do this, she would be committing a crime. Not a lawyer, just know law stuff. I know enough to know if you do these things, that's going to create some problems. Oh, earlier, I skipped over that part. Earlier in the letter, whoever wrote this letter said, I wish I had the names of the jurors so that I could ask them questions. I guess they wanted to like ask, why did you come to the decision that you came to? It sounded like she was very surprised by their guilty verdict and thought that they were going to find her not guilty. And so like they have not just, oh my gosh, okay, so the finished goal, probably final, the finished goal, or maybe is to get finished letters and tape mailed to Judge Duro if there's more to others too, if not just a basic letter to others. Attorney, so this is her attorney, Donna K is her attorney, attorney Pablo B, that's her other attorney, the DA's office with Attorney General Josh, I don't know, Curl, something like that. And then all of these news outlets, including the governor. And then this is what she wanted the letter to say. This is a sample, something like that. Don't say who you are, just a concerned citizen. To whom it may concern, regarding Jessy K, I've watched this trial from the beginning. I never met this girl. She's asking a friend to, okay, no, let's not go there. Jessy K, but what I can tell you is this story is crazy. Anyone who has a brain can tell you this girl didn't do that. And what those jurors didn't hear or what the judge didn't allow makes no sense. You're talking about this girl's whole life because Lynn unalived herself. How is that? Once again, to me, this is coming off as manipulative. This was a total setup, if I ever saw one, by Waukesha County. Well, I spent 3 days in the park, Whitehall Park. Why the detectives never took her to the park. They yelled at her repeatedly. So how would this person know this? Unless this came out during trial. I did not watch every single day of this trial. Unless this came out during the trial, I don't know how they would know this portion. Understanding why she wouldn't tell them if she had evidence. Not understanding why she wouldn't tell them if she had evidence. So she does, and they don't even take her with them. Again, are you serious? I can't even fathom how a jury convicted her. On what? lies. Really, that doesn't make you a schmurder. Point being, after digging around for 3 days, I found her evidence and sent the tape cassette plus papers to the judge in this case. The bottles of Visine and piece of gum, I think, or something, have no bearing, so I didn't include. But this gin, I don't know. I think that says gin. I don't. This girl is to be sentenced to life for a crime that never happened and that she didn't do. I've enclosed a copy of the letters for you, but what I want to know is, what are you going to do about this? Burn, destroy all papers when done. Do not talk about on phone or visit. Make only one tape for Duro, the judge, if you can copy the other pages for everyone in her too. Send the letters to all these people. Wear gloves for all. This is my fight and chance to stir the pot early. Will you help me? I will never say a word, and I will give you a chunk of money if and when I get out, because it's a big favor. And if not, I understand really. Wait a minute. So this is kind of like paying someone. That sounds like that would be a crime too, but not a lawyer. But that sounds like offering to pay somebody to, so not just asking somebody to create false evidence, allegedly, but then also to say, hey, if you do this, I'm going to give you a chunk of money. Tape and record. Jessy, I'm sorry to leave you like this, and I'm assuming you'll be the one to find me after all you have done for me, all the times you saved my life. So this is supposed to be what, like, I think she wanted this recorded or like written, tape recording. Yeah, tape recording to record. So these are the directions for the tape recording she wanted. This is so, and she specifically called it, or whoever wrote this specifically called it stirring the pot. I can't. So please, if you want to dive into all these pages, I've linked it below. I do want to make sure that I cover what the judge said. So let's go over to that. Because the judge was a little upset at the lawyers, because I think the judge was just kind of like, why are we doing this now? Because I guess when all this came in, when everybody was aware of this, and why are we doing this in this public setting? But I don't think the judge asked for that in conference meeting. I don't know. But they have this whole conversation out in public, and we all got to see it. It was very long. I just have some clips from Law and Crime.
When I look at SCR 20:1.16 that deals with declining or terminating representation, there is a section of that under, a little bit kind of odd how it's numbered, but there's a small a at the beginning, and then subs 1, 2, 3, and then under 3, there's in parentheses a B.
I'm not a body language expert, but to me, Jessy looks annoyed during this process. And that's how it comes off to me. And Jessy denies being the author of the letter. I think her attorneys are concerned because it was written on, allegedly, this was all written on some of their trial notes where they know their own handwriting.
Which I believe is the provision for which both of you are seeking to withdraw, that states, except as stated in paragraph sub C, a lawyer may withdraw from representing a client if, 1, withdrawal can be accomplished without material adverse effect on the interest of the client. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 3, the client has used the lawyer's services to perpetuate a crime or fraud. 4, the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. And if you look.
So basically, the judge is going over the reasons why an attorney would be able to withdraw from representation. So let's get to see what the first attorney had to say.
And the ongoing investigation, how is there any conflict of interest?
May I speak?
No, not yet. You are still represented by counsel. No, hold on.
Judge, some of those papers in there have our handwritten notes on them. We know our own writing,
Well, I don't know that, do I?
but well, I'm telling you now.
But see, that's where an affidavit would have been really, really helpful. Could have been filed under seal. Could have given me more information and avoid what I'm doing here in court on the record.
Understood. We recognize some of our own notes from trial.
All right, so you believe at least a part of that filing that has what appear to be trial notes were contemporaneously done during the trial, and you recognize your own handwriting on some of it.
Yes.
All right.
The judge is definitely upset because I think, so for an attorney to come out right before sentencing, this is going to delay this whole process. It just is, because a new attorney is going to have to take time to get up to speed for sentencing.
Limited exceptions to what I would term as the confidentiality requirements between an attorney and a client. Some fall under a shall and some fall under a may. And even if I look under, and it's the SCR 20:1.6, says sub C, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. Sub 1 does not apply. There's not death or substantial bodily harm that you would be preventing. You wouldn't be preventing, mitigating, or rectifying substantial injury to another person. But here's where I think you could potentially be required, or at least asked to reveal, when it would be to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. Even if you believe there's some unwitting use of your services, the fact that part of these crimes for which your client now stands convicted involves theft from the estate and there's a pending probate case, I think one could argue that what's in this letter, if true, I think for purposes of the motion, I have to assume that it's true. I don't think I'm going to give you all the benefit. It's just for purposes of the withdrawal, Ms. Kurczewski, right? Your attorneys have asked to withdraw. I have to base it on some facts. And hold on.
I haven't had representation in the last week though, and I need to be able to speak.
So she keeps trying. So the judge is going to give her a chance to speak a little bit later, and we will talk about that.
You will be given an opportunity.
And I don't think Jessy understands that the judge trying to limit what she says, that's actually for her own protection, that she might say or do something that could legally cause an issue. And so I think that's why the judge is trying to say, you're still being represented by them. And so you can't speak yet. Like, they have to talk, the lawyers and the judge, and that she will be given a chance to say what she would like to say.
To have facts upon which this decision of mine, which is a very important decision, be made. Counsel and defendants oftentimes have a disagreement on strategy. Relationships fall apart. That does not always mean.
So what they were kind of saying is, hey, we don't want this to be precedent. We don't want somebody to do this to try to get out of representation. Like, for somebody to orchestrate something like this on purpose, just so they have to get a new attorney. And it doesn't sound like, just from everything that I've seen and heard, it doesn't sound like that was Jessy's intention. I think she honestly thought she was going to get away with it. I think she thought she wasn't going to get caught. The friend wouldn't turn in the documents. That's just what it sounds like to me.
That attorneys are allowed to withdraw, because as Attorney Sitzberger has pointed out, it would be so simple and it'd lead to absurd results if every time a defendant raised an allegation, whether it be an ethics complaint or criminal activity, if that were enough, we'd never have criminal defense attorneys, right? So there has to be something more. I'm concerned in this case because of the fact there's not a postmark on this envelope.
So there's an allegation that, and nobody knows what happened, but my understanding is there's an allegation that an attorney might have dropped off this envelope. And I think that's why the attorneys went out, because I don't think they fully knew what was inside. Like, I think that's what everybody's going off of. But the allegation is that, and the attorney never said this. The attorney never, to my knowledge, they didn't confirm or deny how the envelope got to this individual. But I think within the letter, whoever wrote it said that the attorney was going to, like, the attorney was involved. That's my understanding.
And I'm concerned that there is an ongoing investigation as to whether it came from the jail, whether it came from you or someone else. There's other things it could be. Like I said, a lot of people watch the trial. I now know that your attorneys recognize their own handwriting. That's very concerning to the court, because very few people would have had access to that. And I have to be concerned with the integrity of these.
The judge was just very, like, it was just, she talked for a while.
I read the cases that the defense cited, and in particular,
Okay, we'll keep going.
State versus Miller. There's a difference when ineffective assistance of counsel and
Did you see that roll? Did you see that? Jessy looks so annoyed. And to me, I would not want to tick off the judge right now.
I don't know your position, so I'll ask you. I don't want you to comment on anything else. Merely, do you want either Attorney Galaviz or Attorney Kugler to represent you at sentencing?
I did. I do not, because up until yesterday, neither one has done anything for me now, because they had halted all proceedings due to the DA conversation they have had. So at this point, as much as I wanted to get out of Waukesha County and proceed forward and go through appeals, I don't, because nothing has been done for sentencing except last minute yesterday. Partial. I have letters of character in limbo. I have nothing completed for sentencing. So no, I don't. And I frankly blame the state for that. They proceeded to.
So if the allegation is true, so that would be very bold. If the allegation is true, if she did write this, to then blame the state for this, that, once again, I'm just getting my opinion. I don't know the situation. I don't know this person. I am getting manipulation. I'm getting twisting things. I'm getting only seeing things from my perspective, from one perspective, pushing all the blame that might be on me. So maybe I did something that caused some of this, and not even looking to my lawyer, but looking to the prosecution to blame them. That was a bit of a leap for me, but I wasn't expecting, when I watched this yesterday, I wasn't expecting for her to blame the prosecution.
To release this information, which should have not been done, and it has created this mess. So while they are requesting they should not withdraw on their behalf, I don't think this is right. Everything has been done wrong since they have came forward last week with this information. And I do say, no, I did not write it. There's cameras all over this jail. There's recorded phone calls. There's a lot of issues here that, no, everything should be stopped. And I need to look at my legal rights, because I don't know what they are at this point. No, I do not think, because of everything.
So the judge can advise her on her legal rights, and she immediately said no. Okay.
Thing that I have since learned, no, I should not have either attorney, which is very hard, proceed at this point, and sentencing should be stopped today.
I can advise you that even if I require them to stay on, I would not go forward with sentencing today, because I'm mindful that there has been a pause. And so knowing that if I were to keep.
And I think the judge, just for appeals, just for anything else, because if she was to say my rights were violated, like I didn't realize that I could have kept them on and sentencing was pushed off another month. Like, so the judge is clearly advising her of her rights, but I think she already has it in her mind. They want to go, and but she's putting it off in a way where it's like, I want them, but because of the prosecution and what this has brought up, fine, I don't want them anymore.
Keep them on, I would adjourn sentencing to give them time to prepare. Does that change your position in any way?
No, I don't think either one of them feel comfortable staying on, so I would prefer not to at this point because of the conversation or little of conversation I've had with both.
So even though she seems agitated in this process, to me, her emotions seem regulated and she seems to be thinking logically and clearly, while there does seem, from my opinion, there does seem to be some like twisting and maybe not fully seeing everything, but not in a way that would point to some like psychosis or in some way that she wasn't capable of making this decision for herself. She was able to make this decision, she made it, and that's what the judge is going to honor.
Both of them, I would prefer not to, no.
Do you understand that could be a significant delay?
Unfortunately, yes, I do. And that is more upsetting, and that is on the state at this point. They released this information. They made this mess. It should have been stopped, but they did this, and that is quite.
And I don't think Jessy realizes that blaming the state in this way, that's not a good look to the judge. And I think the state was trying to use some of this because right now I believe she's facing life in prison. And I think the state is trying to allege like she's not showing remorse. And I don't know what the state, but in my mind, if I was on the state side, I would be thinking like, judge, give this individual the toughest sentence available because they continue to pose a risk to others or something. Like they're not showing remorse. They haven't changed because she's still blaming the state. And to me, that doesn't look good. That's just to me.
Quite frankly, very frustrating. And they have no way to blame but themselves right now. And it is very frustrating. It is very frustrating. And I was told walking out.
The judge is like using all her deep breathing. Like the judge is managing all of her emotions. And because she knows she's on camera right now, because I'm sure that was probably frustrating to hear. I can imagine as a judge, hearing somebody say this with the allegations that have been made, and then to somehow put it back on the state, I would see that as a bit.
The detective's office last week, just so you know, you probably will not be leaving anytime soon because of this, knowing I want to leave. I have not told them I did not write these letters. So again, that is coming from what? My phone calls? My conversations?
All right,
I did not.
We should.
So then she threw in there that she did not tell her lawyers that she didn't write it. And I think her lawyers were just trying to protect and defend their client. And sometimes I think lawyers might not ask a question if they don't want the answer. I don't know. This is so messy. So messy.
I'm going to advise you at this point that I've heard your position. You should consult with an attorney
I would love to. I still have two on record and nobody will
making any
talk to
further
me.
statements.
I've been trying all week. And I have a letter for you that I have tried to get through the jail.
Now, okay, so she wrote a letter, supposedly. She has a letter right now to give to the judge. And I would be interested to know what that handwriting looks like. So this is going to be filed publicly. I'm not going to try to find it, but she's about to give the judge a letter.
Jail, but I will not send it anywhere because I don't trust putting anything out there. So I have had a letter since Sunday for you. I couldn't send it. I have it with me today.
I'll accept that filing today if you would like to provide it, and it will be uploaded and e-filed, and it will be part of the record.
That is completely fine.
So once again, I'm a psychologist, and here I like to cover sentencings just because just hearing the judge's thoughts, sometimes judges provide some of their reflections and they talk about what they've seen during the trial because they had to stay impartial throughout the whole thing. And then once it comes down to sentencing, they're able to use all the information that they've gathered and then they kind of move forward. And I have never seen something like this happen at a sentencing, and I wanted to talk about it. I do just want to reiterate, to me, Jessy did seem incredibly grounded, and she didn't seem like she was irate or like she was irrational or any of those things. Now, she seemed to be in self-protection mode, and the blame was going in a direction that I personally don't think it should have went, because the prosecution did exactly what you would expect a prosecutor to do that received information like that. And so let me know your thoughts in the comments. If you've been following this case, if this was brand new to you, I hope this was something. And I will just be keeping an eye to see what does happen with the sentencing. And the lawyer, covered this one, and some other lawyers I follow might do it as well. But he was talking about whether additional charges may or may not be filed. And since they already have that bigger conviction, not sure what the state is going to do, but they might bring it up in regards to sentencing and whether the judge should go on ahead and give life in prison. Thank you so much for watching. If you like content like this, make sure to like the video and subscribe, and I hope you enjoy the rest of your day.